For our final project on Poe, we are going to do a mock trial. In this mock trial, we are going to decide if the protagonist of either the Telltale Heart or the Black Cat should be found guilty of first-degree murder, or should he be found not guilty by reason of insanity. First off, we're going to have to know what a mock trial is.
We represent the state of North Carolina in this case against the defendant due to rape.
We'll start off with just a normal trial that you would probably see on Law and Order. You start off with an opening statement.
What happened after you made this 911 phone call?
Prosecution puts on their case in chief.
Did you know Baby Brown was put in charge by the lady?
The defense comes and puts their case in chief on as well.
Based on the facts of this case, the prosecution concluded did not carry that burden.
The judges will do some scoring. We'll narrow it down to see that the best round. After we figure out who's the best round, we name out the first place, the second place, and the third place.
The first place does go to our Western Regional Champion, which is Ridge Road Middle School.
I've just been coaching a mock trial team, and I just help them try to develop their trial strategy and a plan, and help them develop questions and opening statements, and help them play the witnesses.
Well, it's a really good experience if you're ever going to be a lawyer later in life, because you learn how to make questions, how to ask questions in the most court.
But I think it also helps with public speaking, which I think is a valuable skill.
It also teaches the kids patience. It teaches the kids to be diligent in their work.
It was really exciting getting to act like a real lawyer would.
It's not only is it fun, it's something you can learn about. I think it improves your argumentative skills.
Always watch like Law and Order with my parents, and I was watching it, I would be like, that's really cool. I wish I could do that someday. And now with the North Carolina Bar Association, I have the opportunity to do that as a kid and learn and be better if I want to do it when I grow up.
These kids are the future of America, and it's great for them to get started in their legal career. And this is one avenue to do it.
Okay, so now that we know what a mock trial looks like, I want to talk about our mock trial. First, we're going to have the prosecution. The prosecution side is the side that is going to prosecute the narrator for first-degree murder. The defense is the side that is going to defend the protagonist in the case. A judge will work to decide the case. We will have witnesses who will come forth either for the prosecution or defense, and a jury will make the final decision in the case. All right, on the side of the prosecution, we're going to have an opening attorney, a direct exam attorney, a cross-exam attorney, a closing attorney, a paralegal team, a reconstructionist, and witnesses, an expert witness, a character witness, or an eyewitness. So we'll have 4 attorneys doing 4 different jobs. The opening attorney will give the opening statement. The direct exam attorney will interview the prosecution's witnesses. The cross-exam attorney will interview the opponent's witnesses. And the closing attorney will provide the closing statement for the side of the prosecution. The paralegal team will gather information and research to assist the attorneys. The reconstructionist is in charge of providing any visuals that are going to be able to influence the jury onto their side and provide evidence. And the witnesses, of course, are going to give their testimony on what they believe about either the protagonist or about what actually happened. On the side of the defense, we will also have 4 attorneys doing the same jobs, as well as the paralegal, the reconstructionist, and the witnesses. In addition, the defense side, of course, has the protagonist. They have the murderer that they're trying to defend. So the role of the prosecutor. This is the job that convinces the jury of the guilt of the defendant through presentation of facts, witness testimony, and providing circumstances showing that first-degree murder definitely happened. They do have the hardest job because they have to prove beyond a reasonable doubt that the defendant is guilty. There can't be any loopholes. There can't be anything that has been left unsaid. They do everything they can to prove that the defendant actually did the murder. The role of the defense is going to be placing doubt in the minds of the jury about the crime through facts, witness testimony, and circumstances. And because we are looking at the insanity plea, they're going to have to show that their defendant was actually insane at the time of the murder. So that's important as well. They don't have to prove that he's innocent because, as we know, the narrator has already committed and admitted that he did it. They do have to establish the guilt about, they have to establish that there is some type of question about his sanity and whether he was actually in charge of his actions or not. The witnesses and the expert witness, they must answer all questions truthfully. If not, they've committed perjury, which can result in prison. They must be prepared for cross-examination as well. This is when the opposing lawyer asks questions to try to discredit them. So not only do they have to know their story, but they also have to know what could possibly be the questions that are asked by the other side, because the other side, of course, is trying to trip them up. The role of the judge. During a trial, an attorney on either side may place an objection to a question being asked by the opposing attorney if that question invites the witness to say something that is going to hurt them, that could not necessarily be in their knowledge, that is prejudicial, or is irrelevant to the case. So when this occurs, the attorney explains why they are making the objection, and it's the judge's job to overrule or sustain the objection. If an objection is sustained, the question doesn't require an answer, so they don't have to answer it. But if it's overruled, the judge wants them to please reply and provide an answer. And at the end, the judge is going to pass a sentence after the jury has reached a verdict in the guilt or not guilty by reason of insanity claim. Court procedures. So this is what it looks like. First off, the defense is going to make their opening statement. And in that opening statement, they summarize the main points of their case, and they tell what each side is going to be conveying to the jury through witness testimony. After the prosecution gives their opening statement, then the defense does. The prosecution is going to call witnesses to the stand and ask them relevant questions concerning the crime. They're trying to establish what happened. During this portion, defense should be taking notes because they're going to be cross-examining each one of these witnesses and doing what they can to discredit them. Oops. The defense then cross-examines each witness. They ask questions that bring clarification or possibly trip up the witness and his or her credibility. All right, so after the prosecution has given all their witnesses and the defense has cross-examined those, the prosecution may object to any questioning, and then they simply say objection and give their reason for the objection. And then, of course, the judge is going to move on that, whether it's going to be sustained or overruled. When the prosecution is done, they will say the state rests, Your Honor, which lets us know it's now time for the defense. So then the defense calls their first witnesses and the proceedings continue just as before. So defense calls witnesses, prosecution cross-examines witnesses, and we carry on. So once the defense is done, they've presented their entire case. This is what happens. They prepare closing arguments in which each side summarizes their position, giving one final push to convince the jury of their side. The defense goes first in this case. The jury then comes to a decision after they look at all the facts and all the witness testimony. And if there's not enough proof of a crime, okay, so in this case, if there is not enough proof that the narrator acted with valid state of mind and that he pre-planned it, then the case could end as a mistrial. If the jury can't reach a decision, a hung jury would result, and in that case, the judge will make the decision. So, I'm very excited for our mock trial. If you do need to again, please watch the procedures video.